The case is now being recorded.
Thank you. So welcome back to the session of the Appeals Court for April 1st, 2024. We're going to hear the next two cases on Zoom. So it'll be case number 5, case number 6. Your panel is me. I'm Greg Massing. With me is Justice Shin and Justice D'Angelo. We have a lot of counsel here. We've allowed the appellant's motion to allow them a total of 20 minutes, which will be divided as we already discussed offline. And so can I ask you, when you are not speaking, to mute your mute button so we don't have any sound interference. But please do stay on the video so we can know you're fully here. And just one thing, can I ask counsel to keep your reactions to a minimum? We can see you, and faces and gestures. I'm sure you won't do it, but some people do, and it's not helpful. So with that, let me call this case, which is 23P874, Department of Children and Families versus Mother and Father. As we met with, so we're going to start with the appellants, and we're going to start with Attorney Openshaw, who's representing the oldest child. And you have 4 minutes.
Yes, Your Honor. Good afternoon, members of the panel, and may it please the court. My name is Laura Openshaw, and I'm representing the oldest child. He's almost 11 years old. He is the only child appellant. The oldest child is raising 2 issues on appeal. First, he is challenging the termination of his mother's rights, and that is the issue I will primarily address today. He has also joined the argument of his father relative to the ICPC, and is asking this court to issue a published decision that the ICPC does not apply to a fit out-of-state parent. Termination of parental rights is an extreme step. It can be justified when the child's best interests are served by a plan of adoption, which requires the termination of both parents' rights. In cases where adoption is not the plan, termination of parental rights can be in the child's best interest. For example, when the terminated parent has been abusive in the past. And in some circumstances, the child's best interests can be served by termination when it serves the child's interest in stability. But that is not the case in every case, and it is not the case here. In this case, neither the evidence nor the judge's findings established that this oldest child's best interests would be served by the termination of the mother's rights. And that termination instead would either compromise or destroy his interests in a continuing relationship with his mother without giving him anything significant in return. There was no evidence that keeping the mother's rights intact would have undermined this child's interests in stability. And that's because the parents had a long established history of working together in his best interests. The parents separated when this child was just 1 year old, and a decade later, the record shows that they were collaborative and cooperative in supporting this child's best interests. There was no evidence at trial, and the trial court did not find that the mother would be likely to embroil the family in unnecessary custody litigation, which at this point would need to be in Pennsylvania. So
isn't that inherent in having the mother's legal rights stay in place? And it's hard for me to see how this case is different from not controlled by adoption of Willow. So maybe you can address that.
Willow is the case that's most relevant to the circumstance. It's different from this case in a lot of ways. In this case, the father was found fit after a lengthy trial where he testified, a family member testified, and there was a home study. In Willow, the father was found unfit, and there was evidence suggesting that even though the children had been reunified with him, it might not go well. And in that case as well, the court found there was evidence at trial that a second parent adoption would likely be in the cards, even if the reunification were successful. That's not the case here. And there was evidence in this case of, on the contrary, a strong relationship between the mother and this child. This is a family that held only virtual visits for a full year. They were just seeing each other through a screen. And when they started having in-person visits again, the child ran into his mother's arms. And there was, and the trial court relied on the evidence of that bond between the mother and the child in finding that post-termination visits were in his best interests. So because the trial court did not make any findings specific to this child whose goal was not of adoption, was not approved, and did not find that termination would be in his best interest, we're asking the court to vacate the termination of parental rights, and we also join the father in the request relative to the ICPC. Thank you.
Thank you. Any other questions from panel? Okay, so let's hear from Attorney Driscoll Weiss, and you're representing the mother.
I do, Your Honor. Thank you very much. May it please the court, Roberta Driscoll Weiss. I'm here today on behalf of the appellant mother. In my brief, I joined with child one's argument that you just heard. So if it is pleases the court, I won't address that particular issue. I would like to address the issue of the trial court's error in finding that the proposed adoption plan presented by DCF served the interest of the remaining children. And it is our position that it does not, and that there was more than adequate evidence for the trial judge to have found that adoption by the proposed Linda S. was not in the children's best interest. That it is settled that the trial judge has to consider, and I use quotations specifically, General Laws Chapter 210, Section 3 requires the trial court to consider the plan that's presented by the department, the adoption plan that's presented by the department. And that's an action verb. It requires that the trial judge actually do something. And if we look at adoption of Dora, what the trial judge must do, it involves much more than simply examining the plan. The judge must perform a careful evaluation of the suitability of the plan and must meaningfully evaluate what is proposed to be done for the children. And that's
so the parents, I mean the G family plan. That was Ms. G did testify, right?
She did.
Okay.
And
take 3 of the children. Is that correct?
I apologize, Your Honor. You cut out for a moment.
Take 3 of the children. She wasn't willing to take all 4.
At the time of trial, she was able to take 3 of the 4 children. And while I admit that that's not optimal, it does not warrant dismissing her mother's and father's adoption plan of Miss Nellie G in favor of Linda S. I think the evidence was overwhelming that Linda S was not a fit parent and not suitable to adopt the children. If you look at specifically, and I think the most egregiously harmed in her care was child number 1, who's now with his father. Child number 1 had specific educational needs. There was evidence that this child could not and was not successful in remote schooling, yet even after COVID restrictions were lifted to enable the child to return to school, Ms. S refused to allow him to return for many, many months, instead having him medicated with antipsychotic medication that she did not understand, the side effects of which she could not identify, rather than sending him back to school. And this was, her reasoning was arguably because she was concerned about the impact that COVID might have on her own family, yet her husband, her son, and her daughter all left the home to go to work every day. So the ones who were being maintained in the home were the children, to their detriment. There was evidence presented that child number 1 and child number 2 both required therapeutic intervention and did not get it for many, many months. When they did have therapy sessions, they were remote. They were observed entirely in their totality by the foster mother. And so neither child was allowed to express themselves or speak freely to their therapist. But most concerningly is the fact that child number 1 exhibited significant and very concerning sexualized behavior towards 2 of his siblings, and Ms. S did not report that to the department for more than a year. Her testimony was clear that even though the sexualized behavior began in 2020, she did not disclose it till a foster care review in 2021. And when asked why she didn't disclose it, she didn't know. She had no answer. She thought someone else might probably let someone, make this known to people, but she didn't disclose it. So I think if the totality of what the Ms. S did not do for these children, I think was very clear in the record. And accordingly, we're asking that the case be remanded back to the trial court for further assessment as to whether or not this adoption plan continues to meet the needs of the children.
Counsel, are there any specific findings of fact that you believe were erroneous?
The findings of fact that were erroneous didn't pertain to the foster parent because the judge made no findings of fact specific to much of what I've raised today. The trial judge did not mention in her findings this questionable keeping the children home beyond the time, scope of COVID restrictions, the failure to disclose the sexual abuse, the failure to monitor the children in person, instead using cameras to oversee their behavior. The trial judge essentially ignored all of that, and that's the problem. That there was no evidence that the judge considered, or there's no indication that the judge considered any of this evidence that contradicted her position or her decision that the children's best interest would be served by adoption by Miss S.
I think just Angela, is your question answered? Yeah, I think we'll have to leave it at there.
Thank you, Your Honor.
Thank you. Next, I think we're hearing from Attorney Foster representing the father of the younger 4 children. Is that right? Okay.
Thank you, Your Honor. May it please the court, Attorney Catherine Foster on behalf of Father P. To first answer Justice D'Angelo's question, there are 2 findings that are clearly erroneous and that indicate the judge's lack of attention to this issue, which are 237 and 238. And it has to do with the fact that DCF lied about the children's behaviors, the sexual behaviors to the parents. In November 2020, when the mother found out that the children were exhibiting sexualized behaviors, she called concerned that the children were being abused. The social worker's response, as recorded by the court in finding 237, was that the social worker said there were no concerns of sexual encounters, although the children were engaging inappropriately with each other. She said she didn't report that there were concerns regarding child 3 as well as child 1. Child 3 began displaying sexual behaviors upon her transfer into the foster home. And she, most problematically, she stated that there were providers in the home working with the family, which is clear from this case that there were no providers in the home between March 2020 and either March or April 2021. So the problem with this finding and then finding 238 is that it seems that the judge, it just didn't occur to the judge that what DCF was saying was untrue, because the judge simply records it as opposed to making a credibility determination. Because then again, in 238 in December, mother called again, concerned about abuse. The social worker again told mother providers. Oh, I'm sorry, I thought Justice Shin, okay. Again told the mother there were providers in the home working with the family, that there were no ongoing concerns when the behaviors were of ongoing concern to DCF, and the social worker testified to that at trial. So those two findings in particular, actually 237 and 239, I'm sorry, are the ones that Father would draw your attention to. In addition, along the same lines, Father's main concern is also the placement with this foster parent who prioritized her own preferences over the needs of his children. where DCF hid the behaviors even from the court, and then lied to the parents, and where, you know, I think it puts counsel for the children on appeal in a really difficult place where they can only minimize the children's sexual behaviors to justify their continued placement, because without evidence that was not collected, there's simply no reasonable explanation for 3- and 4-year-old children to display sexual behaviors that this court and other cases involving natural parents have found support or corroborate findings of sexual abuse.
Well, isn't it the case that the oldest child displayed these behaviors before the placement and afterwards?
There is an indication that in a visit with his father, he displayed some, they called it humping behavior with a pillow, but there's no indication that he exhibited these behaviors daily, which beginning in January 2018, he began exhibiting sexual behaviors daily that only increased until he was removed. And then after he was removed, he only exhibited, there's only one instance in the record to show that he exhibited any of these behaviors again. And in fact, it follows because in 2018, after he was placed, he underwent a complete neurological evaluation that resulted in a recommendation for 30 hours of in-home behavioral therapy and family training, which the foster mother refused. In 2019, he underwent a second separate neurological evaluation resulting in the same recommendation of intensive in-home behavioral therapy. The foster mom both refused and actually withdrew him from therapy for a year because she disagreed with that recommendation. After he was removed and he finally received that treatment, he didn't display the same behaviors anymore. In fact, the social worker testified that not only did he need the intensive behavioral intervention in 2018 and 19, but at the time of trial, he still needed it, but he was receiving it in his new placement. So father respectfully asks that this court remand for further hearing on the children's current condition and well-being. Thank you.
Thank you, Attorney Foster. Any other questions, Attorney Foster? Okay, and so on the appellant side, last we'll hear from Attorney Solois representing Father the oldest child.
Thank you, Your Honor. Good afternoon. May it please the court, Abigail Solois on behalf of the appellant, Father number 2, raising the sole issue of the ICPC's application to a fit parent. Now, in adoption of Knox, this court held that a juvenile court may order compliance with the ICPC in the context of placement with parents if continued agency oversight is necessary to protect children. Knox addresses a situation where a parent was found unfit, and Father 2 is not asking this court to set aside Knox, but Knox left several unanswered questions. The 3 most important being, first, what about fit parents? So the court specifically did not address a situation like this one, where there were no protective concerns because the court deemed Father number 2 fit.
When you refer to fit parents, do you mean adjudicated fit or not proven to be unfit? In other words, is your argument limited to what happened after the decree entered, or are you saying that no home study could have been done pending the case?
My argument, so Father number 2's case is limited to the period of time after he was adjudicated to be fit. So to answer your question, but I do think there's some room in this discussion and some room for the development of the law in the middle period of time as well. But as to Father 2, I'm discussing just the portion of time after the court said that DCF failed to meet its burden to prove Father unfit.
Okay.
So in Knox, there are several unanswered questions, and I think, you know, as I said, it's looking at footnote 14 in the Knox case. The court specifically didn't answer that question. The second unanswered question is whether the Massachusetts ICPC regulations impermissibly exceed the scope of the statute, and that again wasn't answered in Knox. And finally, and perhaps most importantly, what are the constitutional, the due process problems inherent to the ICPC process, and how can they be avoided while still ensuring children's safety? So father number 2 is asking the court to issue a published case holding that the ICPC cannot be required for fit out-of-state parents.
I'm asking that last one. So you're asking the juvenile court to allow a child to go to a different state with no assurance of where the child is going to be, that there's a place for, in the home for the child.
That's not what I'm asking at all. There are other ways that are better than the ICPC, to ensure children's safety as they go across state lines. So that goes to the procedural due process piece of my argument, in that, so the way it works is that Massachusetts has jurisdiction over children, over the child in this case, but with an ICPC requirement, what happens is that all decision-making power regarding that child essentially gets delegated to a caseworker in an out-of-state executive agency, thereby tying the hands of the Massachusetts juvenile court judge. And that's a huge problem, because under sections 24 to 26, the judge must have authority to grant custody at all stages of the child welfare cases. We know that from Dora, that power cannot be delegated. So there are other ways that a judge can get the information they need to keep children safe before they make a decision to send kids out of state. So in this case, for example, father's trial counsel got funds to hire an expert to do an independent home study. So the juvenile court judge had all of that information and didn't have to, delegate or divest that power. So just to point out some other ways, other methods that juvenile court judges can employ. So the court investigator statute. So that's part of section 24 is that the judge.
Attorney, so listen, can you not hear me?
I can, no, I couldn't hear you. I'm sorry. I'm sorry, I couldn't hear you.
Trying to turn up my volume. But in this case, actually, was the child released after the court investigator went? Was there ever the ICPC study?
So in this case, the facts and the timeline of what happened was there was a trial, and the judge said DCF failed to meet its burden as far as finding father unfit, but then said, I cannot give you custody of your child because this ICPC is outstanding. And even before the judge had that, so at trial, there had been an independent home study. So father's trial counsel did a brilliant job of getting funds for an independent home study. This individual went to the home, took photographs, was available for cross-examination, testified at trial. And the judge said, we have no problem with this guy. We just cannot give you your child because of the ICPC.
What if there is no independent home study?
Yes, so thank you. There are other mechanisms the court can employ. So the court has equitable authority to appoint a GAL or order a probation officer to travel to the home of an out-of-state parent. And that, again, doesn't require the judge to divest their authority to an out-of-state executive agency caseworker. So they can certainly gather that information through, as I mentioned, an independent investigator, a GAL, or a probation officer to gather that information.
But before or after the decree enters?
It can be done before the decree enters, of course. It can be part of, so under section 24 is the mechanism for a court investigator. So a judge can order that as part of the court investigation prior to trial. Absolutely.
So if you have, let's say, as a practical matter, let's say you have a petition, care and protection petition that's brought. Nobody really doubts that one of the parent, the out-of-state parent, is fit. What should the procedure be during the pendency of the case before the decree enters?
The judge can order the court investigator to travel to that home and do an independent investigation of that home and come back and report to the court. And then they don't have to wait, because the problem with the ICPC, one of the huge problems, which is referenced in many out-of-state cases, is that there's inherent delays. And I'm not talking about a month, I'm talking about 8 months to a year before we get studies back.
If the court waits until the decree enters and then appoints an investigator or a GAL, you're still talking about a delay.
You don't have to wait. It can be done at the time. So the court investigator is appointed at the time the petition is filed under section 24. So there's no reason to delay.
But you're asking us to issue a published opinion.
Yes.
Are you asking in our opinion that we say what the procedures in juvenile court should be when you're dealing with an out-of-state parent who is not alleged to be unfit?
Thank you for your clarifying question. I think in a published decision, it's important to advise the juvenile court judges that the ICPC is not the only safety mechanism for making sure that children are safe, and there are other procedures to get that information, whether that's through a court investigator, a GAL appointed through the court's equitable authority, or a probation home study, that there are other methods that the judge can employ, and it has discretion and equitable authority to do so, and statutory authority to do so, without thinking that the ICPC is the only way to keep children safe. I see that my time has expired. If I may, before I close, I just want to point out to the court that, and I realize there's a lot of parties on this case, so I apologize, that children and their fit parents should be together immediately, regardless of which state that parent lives in. And I want to alert the panel to the point that just last week, the New York Times published an article, a multi-page piece about the way the application of the ICPC is to out-of-state parents, is hurting children in Massachusetts. This piece just came out on March 25th. The author was Deborah Sontag. If the court is interested, I would be happy to submit a PDF of the article to the court. It just goes to the vast public importance of this issue.
Thank you.
Thank you.
So we now have counsel for the appellees, and we'll start with UCF, Attorney Bates.
May it please the court, Jeremy Bayless for the Department of Children and Families. And I do apologize, Justice Massing, you are very difficult to hear. I don't know what's going on. So if I don't hear you, I apologize.
I'm sorry. Any better yet? I moved my computer. No,
it is better than it was, yes. It is improved. This is a case involving two of the three parents who don't contest that they are fit, nor do they contest that they are likely to become fit anytime in the future. There is a long history of failure to provide a safe and clean living environment for the children, ongoing concerns about violence that there was no indication were only temporary. And as Nancy and Willow make clear, the plans for children whose rights have been terminated are dictated by the fact that the parents' rights are termination. Whether or not termination is done is not dictated by the plans. Specifically with regards to the oldest child, the fact that he had a parent who was not found unfit does not preclude the termination of mother's parental rights. In the point where a mother has demonstrated that she was continually providing an unsafe environment for him, and that she was not likely to remedy those parental failings into the future. The purpose of termination, as the SJC has laid out clearly in Nancy, Willow, and numerous other cases, is to ensure that a child knows that they have a safe and stable permanent home without the possibility of disruption. And so the benefit to the oldest child of that termination was to provide him that legal assurance. That doesn't preclude him having any contact with mother going forward. It only ends her ability to disrupt his life with his father. And that is of value to him, and that was the correct decision. With regards to the other children, and specifically the plan analysis, the primary concerns about the adoption plan that the department put forward were the foster parents' care for the oldest child, the only child who wasn't actually part of that adoption plan. And just as a biological parent may be fit to parent one child and not another due to the specific needs of the child, it is also the case that a foster parent may not be properly able to meet the needs of a child who has particularly heightened needs, but could be perfectly capable of caring for others. And
I just ask you, I heard in Attorney Driscoll Weiss's presentation that there's also an issue of the oldest child's sexual acting out affecting the two of the younger children, so that the foster mother wasn't adequately protecting the younger children from the older children.
So the evidence is not, the department in the record was not convinced entirely that this was sexualized behavior, as opposed to a sort of with the oldest child, as opposed to a self-soothing due to either his autism diagnosis or other conditions. And as was pointed out by, I believe, Father P's counsel, once he received was able to participate longer term in in-person treatment, he's actually had less of that sort of behavior, which would seem to reflect that treating the symptoms surrounding his autism or other diagnoses may have been those behaviors, as opposed to actual sexualized acting out. However, there are also concerns about any sexualized or apparently sexualized behavior in the home were not ongoing up to the time of trial. The oldest girl, who is the other one who had some concerning behaviors, had received some level of services, and those behaviors had improved. And all of those children are FLEs. They are of the opinion that they want to stay in the home. And the court.
So the other children, the four youngest, they have special needs as well, right? Especially, I think the oldest girl. So if I think it was Father P's counsel who argued that the foster mother, Ms. S, didn't report the sexualized behaviors for a year and didn't take advantage or refuse therapy for the oldest child. Why isn't that relevant to whether she's suitable to care for the other children who also have special needs?
It's certainly relevant, and it's evidence that the court received. The court then also had the evidence that the children, other than the oldest child, since the time of the oldest child's removal, were doing well in the home. That there was a period of time where realistically all across the Commonwealth things were not going the way they should due to COVID, but this foster home was determining the best way to proceed with services for the children residing there during an unprecedented global pandemic. And by the time of trial, certainly there had been an extended period where services were back in the home in person. People were seeing the children again. The needs were being met. The assessment of whether or not this plan was appropriate for the children was done as of the facts at the time of trial, not as they were during the peak of the COVID pandemic. So the court did receive and did hear evidence of the issues with service provision in the home and the potentially sexualized behaviors in the home, but they also heard the status of the children at the time of trial when it was making that assessment. And then it was contrasted, that evidence, with the situation involving the other proposed placement, who wasn't even willing to take one of the siblings and would have separated them. And it certainly would have been reasonable for the court to consider that, as that is one of the remaining bonds that those children had. So the court was evaluating the evidence before it at the time of trial and did not abuse its discretion in finding that the Mrs. S was the appropriate placement. As time is running somewhat low, I'll move to the ICPC. Knox does not state whether or not the ICPC applies to a fit parent. However, it provides that the juvenile court or the department, but in this case, the juvenile court, not the department's regs or any other actor, the juvenile court has the authority to order compliance with an ICPC home study if there are ongoing concerns about the children. In this case,
what were the concerns specifically regarding the father, though, that have authorized the court to do anything?
So there were a variety of things that, while they may not have risen to the level of a finding of unfitness, they certainly would have been concerning. Earlier, father was present in the home during a long period of time where some relatively unsettling cleanliness issues, violence issues were going on. He was present, he took no action. Most close to the time of the determination was that during trial, father who had been denied by 2 ICPCs because of space concerns in the home. The department learned that the grandmother had moved out, which made space, which would have, you would think, made space in the home for the children. And then there was a third ICPC home study that was ordered to try and address this issue before an adjudication occurred. And then that was denied because father refused to comply. He wouldn't allow people into the home to see whether or not it was appropriate for the children. I think that is concerning, and that was concerning for the court, which is why, as part of a transition plan, the court ordered that the department request an expedited ICPC home study, and then father participate in that expedited ICPC home study.
The size of the home can't be a reason to deny placement of the child there, right? I mean, so if a parent lives in Massachusetts and they have a tiny home, DCF could not remove that child without some showing of serious risk of harm.
Yes.
Correct?
Yes.
So effectively, by requiring the ICPC home study, you're keeping the child from the home for here, I think 8 months, which is a long time in the life of a child, because of the size of the home. So how is that not a violation of the various constitutional rights that the father raises here?
Well, it goes beyond the size of the home. The earlier rejections were due to the size of the home. At the point where father's final, because my expectation would be that everyone's thought when the third ICPC home study was issued was that was simply a box checking. Grandma's out, there's a room for the kid, Pennsylvania will be satisfied, we'll be good to go. At the point where father refuses to allow people into the home, that raises far more concerns than just the size. That raises concerns of the cleanliness of the home and the safety of the home, which have been issues while father was living with the children before.
What about the independent home study? What did that show?
That showed that reported that the home was fine, but the court was not required to believe a non-independent. I mean, it's presented by a party, so it's not independent in that regard. And the court was, and I believe that was performed before father refused to allow Pennsylvania social workers to see his home. That raises concerns, and that provides sufficient concern for the court to have put that as part of a transition plan. And I see my time has elapsed.
I'd like to discuss just briefly about, again, after the determination of fitness. Once the father is determined fit, what right is there to keep that child away from father?
Well, I think that there's a distinction, and it is between a finding that the department did not meet its burden of unfitness and an affirmative finding of fitness. Similar to the way there's a difference between innocence and not guilty, and we allow the consideration of findings of not guilty by various other courts, even if there has been a not guilty verdict. And so there are still outstanding concerns. There is a court trying to determine where a young child is going to live, and there are not in Massachusetts. A court officer could simply go to the home. Flying a court officer to Pennsylvania, where they would it would be at best questionable that they have jurisdiction to enter the home against the father's wishes, and he's already refused to allow Pennsylvania social workers to enter the home. Furthermore, the child was adjudicated in need of care and protection, and one of the disposition options is to continue temporary custody to the department, and so that was maintained. I think that also goes into the fact that this wasn't a final judgment, as the court expressly ordered ongoing action to occur. So there may perhaps have been a cleaner method of the court to get to the outcome it wanted had it structured its rulings differently. But there were outstanding concerns about the safety of this child. Were they simply...
Why shouldn't this be done prior to the decree entry?
In a best practice, it probably should have been, but that is not what was done here. And in any case where a non-custodial parent has not had the child live with them, there will need to be some level of transition. Obviously, this case had a very, very long one, but the court is still going to oversee the transition of that child home. That occurred in Carla, and that has occurred in other cases. And this was simply part of a plan to transition a child back to living with his father, where there were outstanding concerns about the living environment and the living situation, concerns that were created by father's actions, again, during trial. The best way for this to be avoided was for father to have allowed social workers to see his home, and to hypothetically assume that he would allow a Massachusetts court officer or GAL where he did not allow Pennsylvania social workers is sort of belied by the record, and is the sort of supposition that this court does not need to do at the moment.
Wasn't there evidence that during trial, a court investigator went to the father's home and determined that it was suitable for the child?
Oh,
not a court investigator. I think that this was the independent home study.
Yeah,
person often is a court investigator, and she went and determined that it was suitable, and their findings on that. So what's the reason for the additional delay?
The concern that father was refusing to cooperate with local child welfare services. So which then renders that whether or not that the report from that investigator, which I believe predated father's refusal to allow Pennsylvania in the home, whether or not that was still accurate. The concern in this case was that the children were kept in unclean, unsafe environments that featured violence. Sending them to a home that has that father's behavior has raised concerns that it may not necessarily be as correct, or as clean, as safe, as appropriate as has previously been reported, because now father has changed his behavior around the home. Appropriately raised concerns.
I think we get it. I think we get it. Are there other questions from the panel? Okay, I think it's well over time, so I'm going to let Children's Counsel speak next. Attorney Heffernan, why don't you go next? And you're representing the second oldest child and the youngest child.
Good afternoon, Your Honors. May it please the court, Peter Heffernan on behalf of the second oldest child and the youngest child. I'm asking the court to affirm the orders of the trial judge, finding both parents unfit, terminating parental rights, and approving the DCF's proposed adoption plan for both children. With respect to the second oldest child, at the completion of trial, he turned 7 years old. He had been placed with the proposed adoptive resource in 2017 when he was 2.5 years old. And he had lived there uninterrupted from 2017 up through the completion of trial in 2022. Essentially, he's lived in this home his entire life. There are no allegations that child one was mistreated in the home, no allegations that he acted out in a sexualized manner, or disclosed any other abuse, or presented as having experienced any abuse in that home. The trial judge found that he was up to date medically, that he was in elementary school and was doing well, and that he was, while he was diagnosed with ADHD, he was receiving proper treatment for that condition. The trial judge also found that the pre-adoptive family was able to meet his needs, and that he had a close bond with the family members and his siblings who reside there. The parents' plan for the second oldest child is for him to be removed from the home he's lived in since he was 2.5 years old and placed in an as yet unidentified placement. They did not propose an alternate plan for the second oldest child, at trial. And so essentially the plan that they are proposing for the child is to be removed from his current placement and placed where we don't know at this point. The parents' plan does not make sense. Remand is not warranted here. And it is in the second oldest child's best interest for him to remain in the proposed adoptive placement. With respect to the youngest child, she was placed with the pre-adoptive placement when she was 2 years old, a year prior to the end of trial. And while she has been there, she is up to date medically. She attended Head Start, was engaged with early intervention, and has adjusted well in that placement. The parents did propose an alternate plan for the youngest child, and that is the G family. The foster mother from that home testified at length at trial, as did the foster mother in the proposed adoptive placement. The trial judge had that evidence, as well as the testimony of the DCF adoption worker and the adoption plans, the written adoption plans proposed by the department. She had that evidence. The trial judge reviewed that evidence and based on that made a determination that was within her discretion that continued placement with the pre-adoptive, the department's pre-adoptive placement was in both children's best interest. The judge acted well within her discretion in reaching that conclusion, and remand on that issue is unwarranted. For these two children, I would just ask the court to end this process. A remand would just delay these proceedings. There's no reason for the case to go back to the trial judge, and I would ask the court to affirm the orders of the trial judge. Thank you, Your Honor. If there's no further questions, I would rest on my brief.
Seeing none, thank you, Attorney Heffernan. And last but not least, of the 7 counsel on this case, Attorney O'Brien.
Thank you, Your Honor. Gary O'Brien on behalf of the child number, I believe it's 3 and 4. Not to belabor the point, I guess I would just reiterate on behalf of my 2 child clients what Attorney Heffernan had just laid out in the position of the appellees is the same for the 2 children who I represent. And I would point out, I guess, in terms of the brief, I think all 3 appellees mentioned the I believe it's Ilian case, which I think pretty clearly states out the substantial deference that's offered to the trial court when weighing the adoption plan. And I don't think anything rises to the merits to overturn this case. And that basically that the court considered, albeit perhaps not in explicit detail, the alternate plan offered by the parents, but nevertheless, this court should affirm the decrees on appeal. And again, to reiterate Attorney Heffernan's point of these children have been in care for quite a lengthy bit of time, and we would urge the court not to remand this case, but rather to at least offer these children some permanence in terms of a plan and affirm the decrees on appeal. And if there's no questions, I would rest the remainder on my brief.
See none. So just to close, the case is submitted. I thank you all for bearing with us and getting this done. I think actually counsel for the appellants did a very nice job of dividing it up and making it sort of in sensible chunks in the right order. So thank you for that. And so we're going to ask you to sign off because we're going to take another case after this. Thank you.
Thank you.
All right, just a moment, please. The case is now being live streamed.
Thank you. Okay, calling the last case for this afternoon, 23P773 Matthew Guinea or Guiney versus Stanley Miller. And the appellant is Mr. Miller. We'll hear from you.
Thank you, Ron. Now, what constitutes privacy in one's own yard is at the forefront of this entire matter. The court's privacy calculus is incorrect. Privacy is an issue upon which the entire analysis turns through the lens of what constitutes direct effect on the Gurney property. According to Gurney, the privacy significantly figures into the Guiney's family ability to make use and full enjoyment of the Gurney property. So the right in question is privacy. In the absence of a definition, citation, modification, or anything of legal substance in the record, the statutory definition of that right applies. Even examining the record, however, suggests the appellee meant for the higher privacy standard to apply. Privacy is described by the appellee as loss of privacy, an unacceptable decrease in privacy, significant loss of privacy, and finally, privacy will be significantly invaded if the development of the Miller property occurs. With no overriding factors or underlying issues, Judge Rubin ruled, stating 5 times throughout her decision, a person inside a house constructed on the Miller Foundation could simply turn his or her head to look out onto the Guiney side yard. And this loss of privacy constitutes a direct and adverse impact and provides standing to Guiney to seek the court's determination under 240.14. The statutory definition of privacy is a person shall have the right against unreasonable, substantial, or serious interference with his privacy. Turning your head and seeing into someone's backyard is not what the legislature intended or what the text contemplates when this high standard was enacted. As the word privacy is used over and over again, without definition, scope, citation, or modifier of any kind, surely the legal definition would apply. When the appellee describes a significant invasion of privacy by merely looking into his yard, if there is any remaining ambiguity as to whether or not the statutory definition applies, it must apply. Now, moving on to another area, Your Honor. Based upon the entire record pursuant to the Mancini test, the trial judge seems to have made a mistake. On the first day of the trial, the plaintiff's engineer, using his own engineered plan, Trial Exhibit 9, I was going to ask the court, do you have access to these trial exhibits?
Yes.
Would you have Trial Exhibit 9 at your disposal?
We do.
Trial Exhibit 9, 18, and Chalk 4.
Yes. We have them on our tablets. You can't maybe see, anyway.
That'd be great.
We all have them on our iPads.
Shall I continue?
Yes.
Okay. On the first day of the trial, the plaintiff's engineer testified using his own engineered plan, Trial Exhibit 9, in support, which purportedly depicted my home footprint in relation to the Guiney house. When I testified, I identified a colossal mistake in the plaintiff's engineered plan, depicting my footprint approximately 70 feet from where it should have been. That evening, the plaintiff's engineer redrafted the plan, and it was entered into the record the next morning as Chalk 4, with counsel stating that this was being entered as a result of Mr. Miller's testimony, to which Judge Rubin replied, I understand. Counsel further stated that subsequent brief that Chalk 4 submission was to clarify and put this issue to rest. Therefore, Trial Exhibit 9 did effectively cease to exist and was no longer effectively part of the record. Yet the plaintiff's counsel asked Mr. Morse about his plan and asked if they were identical. Morse responded in the affirmative, but stated the plan had to be rotated properly. If it was, it would line up very well with his own. Now, I was going to explain to the court what rotation means. But I can move on.
So we suddenly have lost we can't hear you anymore.
What's that?
We lost your audio for a second. We can hear you again.
Did you get it
Go.
back? Is it back?
Yeah.
Okay. Okay. Yet the judge relied entirely on trial exhibit 9, an exhibit refuted by both the plaintiff and the defendant to render her decision.
Mr. Miller?
Yes.
Mr. Miller, you agree that Exhibit 9 was entered as an exhibit at the trial, correct?
That was the first exhibit, Your Honor.
And you understand that a trial judge has the right to accept an exhibit if he or she wants.
Oh, I understand that.
So why was it an error for this judge to use Exhibit 9?
Because chalk 4 was put into the record to correct trial exhibit 9. I testified to trial exhibit 9 the first day. Trial exhibit 9 was absolutely incorrect. The opposing counsel understood that. That night, they rewrote trial exhibit 9 and entered it into the record as chalk 4. Judge Rubin accepted that. Thereby, once she accepted that, is my view that trial exhibit 9 no longer existed as a matter of record, that only chalk 4 would be used thereon. Does that answer your question, Your Honor?
Why can't they both be in evidence at the same time?
Because they both show starkly different views. One doesn't even come, if you look at trial exhibit 9 and then compare that to chalk 4, you will see that they don't even come close to being the same. And we're dealing now with engineers who supposedly are able to draw a plan to the inch.
So besides them being rotated, what else is wrong with it?
That's what was wrong with it. It wasn't rotated, Your Honor.
So I mean, everything is in the same place on both exhibits, 9 and chalk 4. Everything's in the same place. Vis-a-vis it's each other.
No, there's two very separate. No.
Okay, so that's
different.
different.
Exhibit 18 is correct. That is the correct placement of my footprint in relationship to the gynae backyard and house. That's exactly what it is. Now, if you compare that to trial exhibit 9, you can see the stark difference between the two. The house of the gynae house is 90 degrees north. The house, my engineer, is 34 degrees south, northeast. So these are starkly different. And just a sidebar issue, the way trial exhibit 9 was written, it indicated that the gynae house, which was one of his allegations, was directly across the street. If you look at trial exhibit 9, it appears that to be the case. But if you look at trial exhibit 18, that is certainly not the case.
If I look at trial exhibit 18, am I supposed to be looking at the orange or the black?
There shouldn't be any colors on that. I don't have any colors on mine.
There's the exhibit 18 that I have. It shows there's black depiction of the two houses, and then there's an orange depiction that's rotated. Which is correct?
If you would trial exhibit 18,
yep.
You see the 50 Harbor Lane, which is located south of the gynae house. Is it looking directly north?
No.
The 50.
Trial exhibit 18 is record 1, page 76, which in my tablet does not have any orange lines.
Okay, I'm sorry. I'm looking at chalk 5 is what I'm looking at.
Oh, yeah, that's okay. That's different, Your Honor. Shall
But
I
18 is correct.
continue?
Can I just ask, why can't you move the house over by 20 feet?
That's not what was originally plotted. There were two engineered plans before the trial started. One, Mr. McKenzie, and one, Mr. Morse. Mr. Morse, my engineer, got it right. Mr. McKenzie got it wrong. On day 2 of the trial, opposing counsel corrected
Mr. Miller,
McKenzie.
let me interrupt. I'm asking you different. The way it's plotted, your proposed house is 30 feet from Harbor Lane, right? Why can't you move it farther away from Harbor Lane?
Oh, because the problem there, Your Honor, is that it's fixed by an order of conditions due to the proximity of the wetlands. So that's why it's there. As a matter of, it used to be 15 feet, but because the neighbors, pitched a fit, I moved it another 15 feet, but the Conservation Commission Board would not let me move it any farther.
Thank you. Well, you have some more time, but I think we understand your arguments, and you feel free to use the rest of your time, but you don't have to.
Okay. Well, Your Honor, if you understand it, that makes my day.
Might not agree with you, but we understand.
Okay, that's fine. But I just do want to say that the final thing I'd like to say is that in Judge Rubin's decision, she only referred to Trial Exhibit 9, although Trial Exhibit 9 was refuted by both me and the plaintiff. We both disavowed it. The plaintiff, to replace it, put in Chalk 4, which effectively deleted Trial Exhibit 9. Yet Judge Rubin used Trial Exhibit 9 in its entirety, not even mentioning Chalk 4. She never mentioned it at all. That Chalk 4 was used to cross-examine my engineer and was used to support my position. But never once in her decision did she mention something as critical as Chalk 4. That was kind of baffling. That's all I have, Your Honor.
Okay, thank you. We'll hear from Attorney Hopkins.
Good afternoon, Your Honors. May it please the court, Robert Hopkins of Phillips and Angley, representing the plaintiff appellee Matthew Guiney. There are two primary reasons why the judgment of the land court must be affirmed. First, Mr. Miller has waived any right to object to the use of the McKenzie plan, what we've been referring to as Trial Exhibit 9, at trial in this appeal. Not only was there no objection to the introduction of the McKenzie plan in the land court, but it was in fact an agreed upon exhibit at trial. Mr. Miller cannot now object to its use by the trial judge in making certain evidentiary findings in her decision. That right was waived when he agreed to admit the plan into evidence. I would also note that Mr. Miller was represented by counsel for the entire proceedings before the land court, and that counsel was, of course, familiar with the rules of evidence. Thus,
Attorney Hopkins,
Yes.
do you agree with Mr. Miller that the other exhibit is directly or contradicts Exhibit 9?
Absolutely not, Your Honor. So when at the first day of trial, Mr. Miller, because the orientation is slightly different between his plan and the McKenzie plan, the reason Chalk 4 was created was to put to rest Mr. Miller's concerns that they were in fact somehow showing something different. That it was created to show when you align it all, that everything is in the same position in relation with one another. That's why Chalk 4 was created. And I will note that Mr. Morse confirmed that the McKenzie plan was an accurate representation of all the materials on the ground. Second issue is that the trial judge's reliance on that McKenzie plan, again, an agreed upon exhibit, when making her evidentiary findings per se means that those findings cannot be clearly erroneous. When you're relying upon an exhibit that's been agreed. That's the definition of relying upon evidence in the record to support a factual finding.
Okay, counsel, how significant does an effect on privacy have to be in order to establish standing?
I would say it's fairly insignificant, Your Honor. And when we think about General Laws Chapter 240-14A, the case law specifically notes that the direct effect that is necessary for an abutter plaintiff to have standing under that statute is less than the quote-unquote person aggrieved statute requirement under Chapter 48 of the Zoning Act. It's a less high standard, and so I think if we would have even proven the higher standard, but it's a less high standard. So Mr. Guiney proved that at trial using these plans that significant portions of the backyard area in which him and his family and his young children recreate would be visible and observable by people in the proposed Mr. Morse dwelling. That would reduce their privacy and therefore lessen the use and enjoyment of their property.
Can I ask you an academic question, Attorney Hopkins? Why would the standing be less onerous under 240 Section 14A than under Chapter 48?
Because 240 Section 14A is intended to be a statute that's intended to give advisory opinions. There's no live case or controversy, unlike under the Zoning Act, where the party must show an actual aggrievement. So the purpose of 240-14A is for either a landowner or an adjacent abutter to seek an advisory opinion from the land court about the either effect of a zoning amendment or the effect of a zoning law on a particular property.
So would Mr. Miller be able to go back to the zoning board of appeals and ask for a variance?
He would have that right, Your Honor, to go ask for a variance if he wanted to.
What's the best case that clarifies how much of a direct effect there needs to be to bring an action under this statute?
Yeah, and so that's, I think, one of the reasons why we had a trial on this. There are not a whole lot of cases that flesh out what direct effects or adverse actions are. I will note Hansen and Harrison are Harrison's the Supreme Judicial Court case, Harrison v. Braintree, 1969. Hansen v. Donahue is from 2004 from the appeals court. I would also note, and we didn't elaborate on this in our appellate briefing, but we did elaborate on it in our post-trial brief, that there are various trial level decisions out of the land court. Brooks v. City of Haverhill, Hanna v. Franson v. City of Woburn, and Savory v. Duane, where land court judges found that proximity alone, being a direct neighbor and a direct abutter to a project, or at least those projects, that proximity alone allowed an inference to be drawn in the abutter's favor for a direct effect.
Where does the direct effect language come from?
I believe it comes directly from Harrison, Your Honor.
Harrison, so, okay.
And I will also, and maybe also Van Rensselaer, direct effect or adverse impact that the abutting use or development.
Now, are those cases establishing that as the test, or are they just saying that because there is a direct effect shown there is enough to provide standing?
I'll quote from Van Rensselaer. It says, "We find no authority suggesting, let alone requiring, that the rigorous standard of person aggrieved used in cases arising under 48 Section 17 be applied to the plaintiffs. It is sufficient for these plaintiffs to have established that they will suffer an adverse impact."
Okay.
And so is your neighbor being able to see you an adverse impact?
It is when the views are of your children recreating in the pool, where previously were no ability of anyone to observe that use, therefore diminishing the use and enjoyment of one's property.
What if he had to stand on the roof to see into the yard?
I don't think that would be a common or a typical way that a property would be used.
So that wouldn't be enough.
I don't think that would qualify. And I will note that you know there are significant cases, the Murchison case being one of the most recent, that under 40A, under the Zoning Act, specifically, you know, identify and speak about loss of privacy, loss of use and enjoyment of one's property as cognizable interests, zoning related interests and injuries under the Zoning Act.
And there was enough evidence, in your opinion, for the trial judge to find that somebody who lived in Mr. Miller's proposed dwelling would be able to see into the backyard?
That's correct, Your Honor. And that's the reason that the McKinsey plan was created. It had not just a top-down view, but what we refer to as a sightline view, showing the relative elevations of what the proposed house would be and what you could see from the proposed house into Mr. Guiney's property. And Mr. Guiney obviously provided significant testimony about his family's use and enjoyment of their property and how these areas are used. And Mr. Morse confirmed that the elevation shown on the McKinsey plan and the placement and the siting of the property and the proposed dwelling were all accurate. So it wasn't just expert versus expert. It was in fact Mr. Morse, Mr. Miller's expert, agreeing with Mr. Guiney's expert about all of the relevant factual data regarding the relationship of the two properties.
And the judge also went and visited the sites, is that correct?
That's correct. We had a site view pre-trial.
Thank you.
If there are no more questions, I would just say that, you know, we understand the position that Mr. Miller has stated. Again, he had this issue the first day of trial. We created Chalk 4 to try to convince him that we weren't trying to trick him, that the plans, the two plans, the Morse plan and the McKinsey plan, really were depicting the same thing. It was just a slight matter of how they were oriented, and that when oriented appropriately, both plans showed the exact same thing. You know, he remains unconvinced, but his own expert engineer understood our position, and his own expert engineer testified that the McKinsey plan was accurate. Yet here we are today, still arguing about this same issue. And so, you know, it's our position that this is a frivolous argument, and we would ask, if successful, that costs and fees be awarded to Mr. Guiney to have to defend against this appeal.
Well, if that's, I think we get your point of view as well, and I see no further questions. So if you have nothing else to add, I think we can.
I have one more thing, Your Honor.
I'm sorry, Mr. Mill, we don't have rebuttal.
Okay.
Thank you. No, so we're gonna take the case under advisement, and that'll conclude our session for today. And thank you, Clerk Cutting, for managing the two Zooms we had today, which were a lot to do. So then thank you both for your arguments.
Thank you.
Thank you, Your Honors.